This courtroom session starts like any other routine docket: landlord-tenant disputes, small claims, scheduling delays. But beneath the procedural calm is a ticking clock, a tenant facing eviction, unauthorized occupants, past due rent stacking up, and a writ that's been signed but not executed. Add in a removed small claims case that suddenly jumps into general civil court, and then a dispute over $1,500 paid to an attorney who allegedly did almost nothing. What looks routine is actually layered with tension, deadlines, and legal pressure. Who's accountable here? And more importantly, who walks away paying? Stay with this one, because the judge is juggling time, fairness, and financial consequences all at once.
All right, there were 7 small claims. 1 has been removed to the general division, and 2 we have no service. At least 4 cases. We are on the live feed. We don't have the record on yet. Good afternoon.
Good afternoon, Your Honor.
Ms. Bauer is here at the courthouse. I haven't seen her in a bit. I don't know whether her client is here or not, but I'll put you both in the waiting room. We're just a couple minutes away from our start time. So
Thank you,
thanks
Your
for
Honor.
being here in a timely manner.
We have been in communication with Ms. Bauer. I believe she is discussing a resolution with her client if the client's there. That was her intention.
All right, I think that's what we're doing. All right, thanks.
Yep.
All right, and we're in hurry up and wait mode. All right, we do have the live feed on, because I thought we were gonna start at 2:45. I hope we do, because I have a bunch of small claims starting at 3. Excuse me. People are starting to check in for our small claims cases. Hello, Deputy Myers. Would you ask Meg Bauer to come in? Meg Bauer from Legal Aid. I think she may be in the conference room. All right, thank you. Bye.
She's on the phone. She'll be in just a second.
All right, thank you. Carl, why don't you come up and have a seat right here? I've got some, that's fine. I've got some time constraints because I got 7 landlord-tenant cases that start at 3.
I guess I won't say anything about my colleague present.
All right, Ms. Sprague, would you join us?
Good afternoon, Your Honor.
Good afternoon. We're going to officially call the case of Mr. Grove versus Donna Carr and all other occupants. File number is 252655LT. We've had multiple hearings in this case. A judgment entered in this matter. A while ago with termination of tenancy. Ms. Carr is there. Also, her daughter, Shandy Faulkner, and another, Patrick Wiltsey, are there, who they're really trying to get out of the complex. Joining us now are Samantha Sprague on behalf of Mr. Grove, and she's been here from the beginning, which has been very helpful. Also, their manager, Cynthia, is present. Ms. Carr is here, and Meg Bauer is here from Legal Aid. And I know the parties have been talking, in fact, probably within just the last few minutes. Ms. Bauer, I'll defer to you. What's our status here today?
Thank you, Your Honor. Defense counsel, I'm sorry, plaintiff's counsel. I'm defense counsel. I refer to myself in third person sometimes, apparently. Plaintiff's counsel sent over a proposed stipulated settlement. There are some concerns that we had. I was trying to make my way through it as fast as possible. I received it probably 10 minutes or so after you and I finished our conversation earlier on irrelevant in this case. My understanding is that Ms. Carr has forbidden Ms. Faulkner and Mr. Wiltsey from being on the premises, and that they have not been on the premises, and that a writ was signed by Your Honor and posted on the door, but has not been executed. I don't know that Ms. Carr was notified of the date and time of the anticipated execution. My colleague informs me there was a concern about the ability to execute it with Ms. Carr not being home. I had asked for an estimate of when they thought that might be occurring so that I could help make sure to coordinate that. I didn't get an estimate of when it might be executed, though they did keep me in the loop that it had been requested, signed, and posted, which I appreciate. At this point, we are simply looking at logistics around costs and responsibility for bearing the cost of the execution of that writ, and coordinating how to facilitate that in light of my client's fixed income and the additional burden of court costs already being close to an entire month's worth of rent for my client. So I am hopeful that we can reach resolution.
Well, there is no money judgment here. It's a termination of tenancy to terminate the tenancy of everybody, including maybe it's just Shandy Faulkner and others. But obviously the situation that's prevailing can't continue. Ms. Sprague, what's your take on this?
Good afternoon, Your Honor. I would agree with defense counsel that we do believe that we are very close to a resolution. I am trying to get the physical file brought over right now to confirm, but I believe that typically with our complaint, we do request a money judgment as part of these issues. Nevertheless, even without a judgment, any conditional dismissal would require the repayment of past due rent. And given that this unfortunate situation, it does not fall on my client. My client did not provide keys to the defendant's daughter and boyfriend to move in. We are going to request those.
I didn't do a money judgment, so there may be further hearing regarding money judgment.
And Your Honor, as Your Honor stipulated previously, there have been numerous adjournments in light of the unique situation that we find ourselves in. At the last hearing on the 23rd, we did provide, I'm sorry, let me make sure my dates are correct. Yes, on the 23rd of Friday, the 23rd, we did provide a copy of the judgment to the court. Immediately, we also contacted the court to see if there was any way to provide payment. We spoke to a lovely clerk that did provide us an online payment tool that unfortunately is not supposed to be used in landlord-tenant matters, which we were apprised of after the fact. So that did unfortunately result in a delay of the writ for that payment to process, which is why the writ was signed on Wednesday as soon as that payment cleared. And the process server did post, but was unable to reach Ms. Carr. We were informed of that earlier today. Given the continued adjournments, we are hopeful for a conditional dismissal wherein payment would be made again for that past due rent, as well as the court cost, and then a probation period. So I understand the court's position is that you typically would adjourn
Do
on
we
the
have an
issue.
estimate of what the costs would be? I mean, she was there. Once a termination of tenancy is filed, they can't accept rent, but once the judgment is obtained, they can go back after that rent. So how much rent is due?
Currently, there is past due rent in the amount of $1,375.80, or I'm sorry, $1,110. That does include late fees of $30. We would note for the record that at the first hearing in which we had appeared, which was several hearings ago, Park Forest was, defense was waived by the defense counsel in order for the defendant to pay rent, and no payments have been made since that time. And so again, we would be looking at $1,110 plus court costs, the amount of $275.80 for a total due and owing of 1,300 and my apologies,
Here's where
Meg.
this landlord-tenant case gets legally interesting. The court already entered a possession judgment, meaning termination of tenancy has happened. But no money judgment was entered yet. That distinction matters. The landlord reserved the right to pursue unpaid rent later. And now we're seeing that number crystallize, over $1,300 in rent and costs. The defense doesn't dispute most of the rent, just the $30 late fee. But they're concerned about the unknown cost of executing the writ. And that's key. Once eviction enforcement begins, those fees can add up fast. The judge is balancing urgency with fairness while managing a packed docket. Should a tenant on fixed income bear enforcement costs triggered by unauthorized occupants? Or is that simply part of the responsibility of signing the lease? Let me know. What do you stand on that?
Indicating that a money judgment is sought.
A money judgment was sought, but I checked the box. No money judgment was entered at that time.
As to
So
the
you'd
default
reserve
possession.
the right to request a money judgment, but I didn't enter it as a part of that.
Correct, Your Honor.
So the defendant doesn't get a free pass on a rent because she's got two unauthorized people in her apartment that are causing all of this turmoil. As you indicated, she's the one that let them in.
Judge, again, we don't dispute the
All right.
rent sought,
Okay,
with the exception of the $30 late fees.
all right. So they're late fees, and there's the issue of they're late because I can't pay the rent because of Park Forest.
Exactly.
So,
Well,
but then there's going to be a cost of executing this writ, which we don't know what it is. Now, I also have 7 people waiting for small claims starting in 2 minutes. So I can start to address those and you guys can continue to discuss this. But I'm not sure what do you, well, let me ask you, Ms. Sprague, what would you like me to do?
Your Honor, if you could give us a 20 to 30-minute adjournment, I don't know that we'd even need that long. We were making really good progress. Unfortunately, time just got away between my court docket and Ms. Bowers, and we weren't aware until this morning that the writ had not been executed yet.
All right. Laura, would you open the Zoom conference room? And we'll put everybody in breakout. I've got other business to deal with, and then you guys can talk without time pressure while I work on these other matters, and then we'll come back to this.
Thank you, Judge. Thank you, Your Honor.
For our small claims parties that are joining us, thank you for just trying to resolve a difficult landlord-tenant case. We're gonna pause that one while we take up our small claims docket.
Pardon me. I think I got something.
All right, let me open a break dancing room. I will put Mr. Grove, Samantha Sprague, the Zoom room. All right, you guys all join that. I'll be here working on other matters, and we'll come back to this when you're ready.
Okay, thank you, Your Honor.
All right, so let's turn it back on. The live feed is still on. I'll just leave it as it is, but we've restarted the record. It's time to address our small claims docket. And we have several matters. Susan Keith is here on behalf of Z-Smart. And we've got, I think, no defendants. We do have Christina Millard and John McDonough are both present. And Teddy McEachern is present. We're going to address that matter. Ms. McEachern, would you join me, please?
Good afternoon, Your Honor.
Good afternoon. This is file number 252657SC. It's entitled Teddy McEachern versus James Rund and Catherine Rund. This is a small claims matter for $7,000 regarding the sale of a home and the inspection regarding a septic system. The claim is for the statutory maximum of small claims, which is $7,000. The defendants, James Rund and Catherine Rund, are not present. They've hired a lawyer and removed this matter to the general division of the court, which either party has a right to do. So it's going to be in general civil court with all the rules that apply, rules of procedure, rules of evidence, rules of filing. It takes it out of the small claims.
This is a strategic legal move right here. By removing the case from small claims to general civil, the defendants just changed the battlefield. Small claims caps damages at $7,000 and keeps things informal. But general civil? Now we're talking full procedural rules, formal pleadings, evidence standards, and potentially up to $25,000 in damages. The plaintiff didn't lose today, but the case just became more complex and potentially more expensive. That can pressure someone without an attorney. It's a reminder that removal isn't about running away. It's often about raising the stakes. Was this defensive strategy or escalation? Because now both sides are in a much more serious legal arena.
Did they serve that on you, that demand for removal?
I have not seen it as of today. No, sir.
Well, they have to file an answer. They're removing it, and they have to file an answer. And the defendant has 14 days from the date of this order to file a written answer. So I signed it just now, and I've yet to see their answer. you can you can hire a lawyer and you can amend your claim for up to $25,000.
Okay, I certainly will be amending the claim because my
All right.
expenses have well exceeded the 7,000. Unfortunately,
All
I
right.
do not have the resources to hire an attorney. So am I able to represent myself?
Yes.
Okay, this claim seems very straightforward, so I feel comfortable in doing so.
Well, I haven't gotten far enough into it to know, but at any rate, if you're going to file an amended complaint, I would just wait till you get this removal order. We'll set a pretrial. You can file an amended complaint to sue for up to $25,000 and serve a copy on the defendant, and then we'll set further proceedings. But we're out of small claims and into the general civil arena. So
Okay, so I just wait till I get the information from them, and then there'll be directions
yes,
in there and how
well,
to
defendant
amend
has 14 days to file an answer. So I just signed it today, so today's the
Okay.
2nd. They have to file an answer by the 16th.
Okay. And will I be notified if and when they file an answer?
Yes, they should serve one on you.
Okay.
We're not in small claims, we're in general civil. And if you file an amended complaint, you need to serve it on them. All right. Anyway, we didn't win or lose the battle. We simply changed the arena in which it's going to be fought. So I'll still be me and it'll still be district court, but it will be in the general civil. So anyway, I won't take any more of your time. You'll get the order removing it, and within 14 days, you should get an answer.
Okay. All right.
Thank you.
Thank you for your time. I appreciate it, Your Honor.
All right. That's why I'm here. Thank you. All right. Susie, we'll get to your cases in a minute.
Somebody might not be. Let me try that again. Okay, I'll call you back.
All right. Here's John McDonough. The next matter is Christina Millard versus John McDonough. The file number is 252682SC. This is a small claims matter. Miss Millard is suing for $1,500 for money she says she paid for legal services and never got the services and never got the money returned. So I'm going to ask if you would both please raise your right hand. You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Mr. McDonough? You're on mute. I can't hear you.
Sorry, Your Honor. Yes, I do.
All right, very good. Let me explain. John, you probably understand all this, but Miss Miller, this may be a little less familiar to you. We're in small claims court, and in such, the rules are different and more relaxed than general court. We don't strictly follow the rules of evidence or procedure. I will allow documents without a lot of supporting affidavit or that sort of thing, foundational requirements. But both parties are under oath. The claim is limited to $7,000. Neither party is allowed to have an attorney in small claims court. There's no formal record being made of the proceeding in small claims court. There is no appeal from small claims court. Any decision made here is final. Either party has the right to remove the matter from the small claims to the general division, as was just done in the last case, but you have to tell me that before we start. Miss Millard, are you ready to proceed?
I am.
All right. And in your claim, you indicate that you retained Mr. McDonough when he was in private practice as an attorney to represent you in a divorce matter, and nothing was done and you never got your money back. Is that your contention?
That is correct.
Mr. McDonough, what's your position?
Well, I do remember having a lengthy meeting with Miss Millard, and I believe it was her mom who also came in to my office that afternoon. We met We went through all of the information that was going to need to be required for a complaint for divorce. I kind of listened to what her story was and jotted everything down. Um, kind of prepared a template complaint for divorce that day, and then when I finished in the office that day, took the check and deposited it into my account, and shortly thereafter, I don't remember if it was the day after, she contacted me and talked to me about them potentially reconciling, but he had hired Jay Felt, and Jay Felt was potentially going to handle the case. And I told her that I would speak to Mr. Felt, which I did. And he explained to me that he thought he was handling their entire divorce. And at that point, I thought um, matters were settled. She had been explained what a retainer fee was and that it wasn't something that she would um, be given back once she paid it. And I believe I followed my part of the bargain. She ended up um, dealing with this with Mr. Felt, but I certainly didn't have any intention of not following through with everything that she would have needed. It was my understanding that um, this matter was over and done with. And I don't know if there's a statute of limitations or not, but it's been nearly 3 years or 4 years since I heard
The
anything about.
statute of limitations is 6 years.
Okay,
Uh,
this is my first dealing with
small thing.
small claims as well. So,
All right. Well, what she says, I paid a retention fee for services provided during my divorce. The check was cashed. I did not hear anything back. There was no work accomplished. Ms. Millard, did you sign any sort of retainer agreement or anything?
I did not sign any type of agreement with Mr. McDonough. Yes, initially I met with him a couple times actually, and we had like a consultation about what was going to happen. There was one point where my ex-husband and I thought that we would reconcile. So I asked if he could just put it on the back burner, just hang on to the money. And he said he would hang on to the money. It's not going anywhere. It's in a trust fund account. And then after that, we proceeded to continue with the divorce. And I was reaching out to Mr. McDonough, and he stopped replying to my text messages and my emails. And then I went to his physical office where he was, and they said that he didn't work there anymore and they couldn't tell me where he was. So it was just kind of all the communication was lost, and I just didn't hear anything back from that. So I just continued doing everything on my own with the divorce.
Did he file any pleadings or do anything else on your behalf?
No, he did not.
Did you ever get a chance to ask for the money back?
Well, that's in the text messages that I was sending to him when I was reaching out. I'm like, are you getting my emails? And it was just like no response whatsoever. And I couldn't find him. And at that point, it was just a lot of stress that I was going through at the time. So I just I was just going to let it go. But then recently I was thinking about it and I'm like, that's not really fair. He didn't really do any work for me. So why should he get to keep that money?
All right, Mr. McDonough, any last response?
no, my contention would be that some work was done, and that once I spoke to Mr. Felt, who I believe was the party in the divorce, and he told me that he was handling it for everyone, I kind of forgot about it.
All right, Miss Millard, you're the plaintiff. I'll give you the last word.
I think I said if, oh, sorry.
All right. So you never got any response to any of your texts or emails or requests for your money back. Is that correct?
That is correct.
All right. The statute of limitations is 6 years. Apparently she let it pass and then decided that she didn't think it was fair. Essentially, Mr. McDonough got $1,500 for a consultation. There was no retainer agreement ever signed. She paid the money in good faith. Mr. McDonough said it was in a trust fund, which is where it's supposed to go. But he didn't do any work. But he did meet with the defendant on a couple of occasions. I'm going to allow some consideration for that. I'm going to order that you repay $1,000 plus $66.25 and $43.18. So the total is $1,109.43. I will allow $500 is pretty generous. I don't know what his hourly rate was, but he did perform some service in consulting with you and you paid the fee. He then discussed the matter with Mr. Felt and discussed it with you again, but no work was performed. I'm just going to do this judgment. It's due within 30 days, or you can pursue collection on this matter. I did allow some consideration, as I said, but 500 is probably generous for the amount of work done. He didn't respond to text or email messages and didn't refund the money. All right, $1,000 plus $109.43 of costs, which was $1,109.43. I guess we could do an installment. Mr. McDonough, could you pay an installment, or would you rather just try to pay it all at once?
I don't know. I need to figure it out.
All right, I'll just leave it as
What
What
this.
started as a basic non-payment eviction evolved into a procedural storm. The tenants withheld rent, claiming repair rights. Their advisor, who later became counsel in circuit court, held the funds in an account where she was the only signatory. The judge identified a potential agency conflict. If she acted on the tenant's behalf in controlling funds, she may be a necessary party. And if she's a party, she cannot represent them. The result? She withdraws. The tenants are left without counsel. The case is adjourned to December 19th, 2025. Legally speaking, this hearing wasn't about deciding the eviction yet. It was about stabilizing the process. The court prioritized procedural fairness before moving toward trial. And now the bigger question remains unresolved. Do the tenants legally withhold rent under repair doctrines, or will this default the lease? This case is a reminder. Courtroom battles are not just about who's right. They're about who followed the rules. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
100 and how much?
1109.43.
Hi, Judge. Do you
Hi.
intend to be on the record still?
Let me stop this.
Okay.
Thank you. All right, Miss Millard, best of luck.
Thank you.
Hi, I'm in the middle of small claims. I can
I'm
stop the
sorry.
record. I'm on the live feed. You don't have to apologize.
Okay.
Judge Pattison has the prelims for tomorrow.
Okay.
And I know you were discussing a possible waiver in your case, but he's got all those, and
Okay.
my apologies to him. It went from odd week to odd week.
Okay.
We're still trying to determine whether we got a trial on Sinquest Furlough on Wednesday.
Yes. Mr. Chucky and Ms. Stoll are working on that.
All right,
And I'm kind of in the wings, keeping an eye.
all right, thanks. But you guys can go see if Judge Pattison's back and touch base with him.
Very good.
Okay,
Thank you,
perfect.
All right,
Judge.
Thanks,
thank you. Okay. All right, Susie, it's all up to you now. You're at fault for all of these. I mean, you're in charge of all of these. We have 5 or 4 Z-Smart cases, but let me call a couple of others first. Nathan Brooks versus Windy City Auto and Diesel. No one has appeared for either side, but the defendant hasn't been served. Probably won't be. So let's take up the Z-Smart cases. Ms. Keith, would you raise your right hand? Swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
All right. The first case, well, we'll do these last. Let's do the ones where we got service. Z-Smart versus Dale Dieter. This is a claim for $991.61. Mr. Dieter was personally served. He is not here. It's a claim for $991.61 plus costs of $66.25 and $60.80 for a total of $1,118.66. Is that matter still due and owing?
Yes, it is.
$1,118.66. See judgment. Z-Smart versus Jonathan Baker. File number there is 252499SC. This is a claim for $1,875.67. Let me click onto this one. I get my cases confused. Some of these were betting. This one was an e-bike. Jonathan Rader, not Baker. I'm sorry. This was a stereo. The request is for $1,875.67, $1,775.67 plus $100 in field visits. Has anything been paid on that? Defendant was personally served on January 17th, and he's failed to appear, so he's subject to default. $1,875.67 plus costs of $86.75 and $70.36 gives us $2,032.28 by default. Ms. Keith, as you know, the easy part is getting the judgment, the hard part is getting the money, but this is a start. The next one is Z Smart versus Mitch Crago. This is a claim for $2,658.60. He previously got a judgment against Amber Crago. And you were able to get personal service on Mitch Crago on January 5th, and he has failed to appear. Is this money due and owing?
Yes, it is.
Have you recovered anything from Amber?
No. Before it went to court, they were going to return it, but when we went out to pick it up, the laptop screen was broken, the TV had evidence of roaches, and they left the furniture out in the rain, so we couldn't pick it up. So
sounds like a bad deal all the way around.
Yeah.
All right, I'm going to do the judgment, but it's going to be joint and several with Amber Crago, so you don't get to collect the same judgment twice.
I wouldn't do that.
No, I know that, but damages are $2,658.60 plus $106.50 and $58.62 in costs for a total default judgment of $2,008.19.72. Kim will probably clean that up. 281972. Well, the cases certainly go faster when the defendants don't show up, but each of these cases we just did, the defendant was personally served with these. Next, we have Z Smart versus Rosalie Wittendorf and Brandon Wright. We don't have service on either party.
I talked to Bruce. He was waiting for the mail check thing to come back. So we're probably going to have to push that out because they were evicted.
Yes. No service, continue at least 30 days. To attempt service. I think that's it, Susie. 3 defaults, Crago, Raider. and deeder. And one non-service. And a non-service on Brooks, removal, and one contested case. I think that's all we can do today. As always, you can get those judgments from Kim and see where we go. All right, anything further we need to address?
Nope.
All right, I'll see you next time. Thank you.
Thank you.
Well, we set aside our landlord-tenant case, did our small claims, and they're still working on the landlord-tenant case. So I'm going to stop the live feed for now.